Hi, this is Kip from Malcolm Malik. Sometimes it's interesting to look at cases and situations that occur in other states. And I was reading about a case that occurred in Louisiana, and I just thought it was interesting how it played out in Louisiana and how it would actually play out in Ohio. So the situation was such that there's this individual, and this guy, the background of this guy was he had like anger management issues, I guess. And he was kind of, I don't know, curmudgeon-y because the stuff going on in his life. And what ended up happening is he was like a security guard in a hospital. And in the hospital, there was a patient that threatened him and then threw bodily fluid, blood or urine and on this guy, which is absolutely disgusting. So that's what happened. And he may have been attacked as well, but I didn't read that he got attacked. I just read the bodily fluid bit. So, and I was like, it was kind of interesting because what ended up happening in Louisiana, he filed for whatever the what you can in Louisiana, the workers' comp claim there under their system, and his claim was allowed for PTSD, and I was like, I don't think that would. If all that happened was he was exposed to, and I'm fairly certain that's what happened, exposed to bodily fluids, that's not how it would play out in Ohio. Unfortunately, it would be nice if it did, but it doesn't. And the reason why it'd be nice is because we represent a number of folks who work in correctional facilities, and what ends up happening is what happens in correctional facilities, I guess you get thrown bodily fluid on you. And so this happens to some of our clients. And under Ohio law, if you get bodily fluids thrown on you, blood or whatever, if you're a correctional officer, a police officer, EMT, firefighter, whatever, they'll pay for post exposure diagnostics. But would you be able to file for PTSD? Like, let's say your claim was allowed, and it would be allowed for exposure to bodily fluid. You probably wouldn't be able to file for PTSD. I mean, you could do anything you want, but the reality is, would it be allowed for PTSD? And likely it would not be, at least not administratively. And if it ever got to court, if it didn't get motioned out, it may be allowed by a jury, but it would pursuant to workers' comp law, frankly, it would be decided wrongly. Because in Ohio, you could pursue psych conditions, but they have to basically flow from the allowed physical conditions. And so generally speaking, that requires a fairly significant physical condition. So you don't typically see folks found and getting allowed. I mean, you could do whatever you want, but you typically don't see folks filing for psych conditions when it's like a soft tissue condition only. So like if you have a lumbar sprain, I would say it's less likely it's going to get allowed for like depression or PTSD. Generally, you'd have to have, disc herniation. You'd have to have surgery and these things because again, it's said to flow from the allowed physical condition. So, anyways. Somehow in Louisiana, this guy got his claim out for PTSD from exposure to bodily fluids. Frankly, now, practically speaking, that's how Ohio would treat it, and apparently Louisiana would allow you to get PTSD. I'm kind of inclined to say, hey man, if you're exposed to blood or bodily fluids, by all means, that would probably cause me PTSD and most other people PTSD. And I don't think it'd be entirely unreasonable to have that kind of impact on somebody, possibly. But so that's kind of the reality. But that it just wouldn't be allowed in Ohio. Likely wouldn't be allowed. And I'll just speak from experience. Like I've had folks who were in situations which reasonably would cause PTSD. Individual who was running out of a building that a gas was leaking out, and the gas ended up causing the building to blow up. Well, that would cause anybody to have PTSD. had another client who worked for a transit company, a bus company, and their bus was getting shot out. And, the bullets were, shooting by them, their head, but they didn't suffer any physical injury from that. And so, PTSD wouldn't be allowed. So yeah, but anyways, so this guy, not only did his claim get allowed for PTSD in Louisiana, which is more generous than what would happen in Ohio probably, but he also claimed that he was unable to work. He was permanently and totally disabled because of getting this bodily fluid thrown at him, and the PTSD had causes anger management issues to flare up, and it prevented him from working. So in Louisiana, I guess it's kind of similar to Ohio, but a little bit different. But the analysis of whether or not somebody's entitled to permanent total disability is whether there's a reasonable probability with the appropriate training or education the employee may be rehabilitated such that he can achieve suitable gainful employment. So, i.e., can this person, through training or whatever, potentially become employable again? And so that's the analysis. And in this situation, the Louisiana Supreme Court. So what do you think? Do you think the Louisiana, not Supreme Court, but the Louisiana court, do you think they granted PTD, or do you think they denied PTD? So that's the question. I'll give you a second. Okay, well, you can kind of get the gist of where this is going. They denied it, reasonably so, I think, and they denied it because it was found that this guy was able to take care of his kid or his kid brother. I guess he mowed his neighbor's lawns, and then he took care of, I guess, godchildren or something. So because of that, he was denied PTD. So, and frankly, I don't know, man. I'm not crazy about this fact pattern. I think the guy should be able to go back to work too. But I'm not the guy, and maybe this changed his life, and maybe this anger management thing was such a huge barrier to him that he wasn't able to work. I haven't walked in that guy's shoes, so I can't really say. But I could just tell you that in Ohio, one, the claim would not be allowed for PTSD, unfortunately. And then two, it definitely would not, he would likely not be granted permanent total disability. And they would say, there's some kind of job that this guy can do, and he would probably not be found medically PTD, so they would look at what's called the Stevenson factors, and they'd say, hey, this guy, he could do some other kind of job, and he's able to mow the lawn for these people, he's able to take care of these kids, so he should be able to work somewhere. So they would probably deny PTD in Ohio. So it's interesting kind of thought idea, to think about how other states treat things differently. And I talked about this post-exposure diagnostic deal in one of the shorts. And that was a commission order that was in reference to. And that guy, this EMT that was ventilating some hepatitis C patient, apparently his claim was initially disallowed. So because the way it works is to get to a full commission, it has to be denied for somebody. And so evidently for this guy, the DHO and SHO had denied, allowing the claim for exposure to bodily fluid. But then the question is, okay, great, it's allowed for exposure to bodily fluid, but what is that going to do for the guy? And I mean, all that does is it pays for his post-exposure diagnostics. That's it. So when you get post-exposure diagnostics, they're either to find something or not find something. And this guy was ventilating this dude with hepatitis C, got vomited on. Well, what if the post-exposure diagnostics showed hepatitis C? Would he automatically, get a claim? Would he automatically be able to add, a condition or diagnosis of hepatitis C to his claim as a compensable condition? And the answer is no. I mean, he'd have to show that the hepatitis C was a result of exposure to, this individual with hepatitis C. And there's like a whole analysis for that sort of situation. I mean, the reality is, unless this EMT was, a former intravenous drug user or something, the reality is he probably would be additionally allowed, but it's not like a guarantor or guaranteed thing. And if there's any wiggle room for the employer to deny something, they're definitely going to exploit that. And, they're definitely going to bring up any and all defenses that they can at these hearings. But that's, hopefully this guy didn't get hepatitis C, but if he did, he'd have to add that condition to his claim and pursue it, and again, it may be denied. So anyways, as I say at the end of all these videos, workers' comp in Ohio is a complicated beast, and it would be a grave mistake for you to do it on your own. I highly recommend that you get a workers' comp attorney involved, and it's going to pay dividends. It's going to pay massive benefits if you do, and if you don't, you're going to run into problems. So if you have workers' comp, if you have a work injury, ask your mom, dad, friends, neighbors, coworkers, hey, which attorney did you use? And maybe talk to that person. Otherwise, look up on Google for workers' comp attorneys. Talk to one attorney, talk to 10 attorneys. Just find somebody you like, somebody you vibe with, and hire that person, and then go from there. So as always, I appreciate you watching this video. If you have questions, concerns, comments, go ahead, email me or leave them in the comments below or call my office. And I wish you stay safe and have a nice day. Thank you. Kip from Alec and Malik.